Good evening, everyone. My name is Laura McGregor, Professor of Scots Law in the University of Edinburgh. On behalf of the School of Law and its Head of School, Joe Shaw, it's my very great honour to welcome you to the inaugural lecture of Professor Gillian Black, Professor of Scots Private Law at the University of Edinburgh. Gillian has had an interesting and varied career, and it's been a real pleasure for me to see the many accolades that Gillian has received, most recently in her appointment as Commissioner at the Scottish Law Commission. Gillian is a graduate of the Law School at the University of Glasgow, graduating in 1999 with first-class honours and being awarded the Bennett Miller Prize for Excellence in Private Law. This is where we first met, Gillian being a student in the first honours seminar I ever taught. Fortunately, that experience doesn't seem to have held her back, as we can see this evening. After graduation, Gillian decided to go into legal practice, completing a training contract at Shepherd and Wedderburn and working there as a qualified solicitor. The pool of academia seems to have been strong, however, because she returned to Glasgow Law School as a teaching assistant in 2004. She studied for and completed a part-time PhD at Edinburgh Law School on the topic, a right of publicity in Scots law. I distinctly remember that Gillian had to obtain special permission from the university to submit her PhD thesis early. And I'm sure you'll agree that this is unheard of, if not unique, and a mark of Gillian's hard work and her dedication. She then moved to Edinburgh Law School to become lecturer and senior lecturer before taking up her current chair in 2020. The long list of Gillian's publications is testament to her wide interests. In a world of increasing specialisation in academia, Gillian has mastered different areas of the law. She is the author of leading books and articles on, for example, contract law, publicity rights, and family law. In recent years, she's dedicated her time to her role as Law Commissioner. She's the lead commissioner on the Aspects of Family Law Reform project, which is currently focusing on civil remedies for domestic abuse. I know from speaking to Gillian how fulfilling she finds this work. It's incredibly important for academics to be given the opportunity to really shape the law as part of a commissioner role. Gillian is also an academic associate at Harcourt Chambers and visiting professor at Napier University. Now, one might question whether she would have time to do anything else, in addition to the very important role of being mum to Ewan and Roddy. She is nevertheless very interested in heraldry and is currently Linlithgow Pursuivant Extraordinary in the court of Lord Lyon. Now, because of recent events, we've seen much of Gillian in her significant duties in this role, and her colleagues have enjoyed watching her on TV, for example, at the King's coronation. I've emphasised the varied and interesting nature of Gillian's career. There is a theme which unites Gillian's work, and that is, simply stated, equality, and the need to stand up for those who are unrepresented or oppressed. The work that Gillian does is not always easy. It takes courage to speak out on the issues which she is concerned with. And in her publications, she gives voice to those who may otherwise struggle to be heard and makes us reflect on their challenges and concerns. It's very important work, and I suspect that we may hear more about it in her lecture this evening. So I would ask you now to join me in welcoming Professor Gillian Black to the floor.
I'd like to thank Professor McGregor for that introduction. As she mentioned, we've known each other for quite a long time, and she's been such a significant and generous friend and support and mentor. I think you've had the single most significant impact on my career, and it's an honour for me to have you chair my inaugural this evening. In fact, here we are. I think about 15 years ago, when the Edinburgh Centre for Commercial Law hosted an annual lecture, and I think it's lovely to see two brilliant legal minds there, along with Lord Hoffman and Lord Reid. Now, I know that this will be a memorable occasion tonight, full of entertainment and drama. There will be highs and lows. You'll laugh, you may even cry. All of that, of course, is coming your way at 8 o'clock, but before then, there's this lecture, a fixture which I'm pleased to say will not last for 90 minutes. In fact, I'm aiming to stop at half-time, 45 minutes in, and there will be wine for half-time refreshments. It's also probably appropriate to give a content warning at this stage. I can't predict whether Scotland will provide an emotional roller coaster, as is their wont, but I can say that I will touch on some difficult subjects in this lecture, including domestic abuse and rape. I will try to do so sensitively, but I have to say that the quotation I have from Sir Nicholas Fairbairn leaves something to be desired. But without further ado, thank you all so much for coming. It means so much for me to see so many friends and family here this evening from across my career in law, from my undergraduate days at Glasgow Law School, through my traineeship and my time at Shepherd and Wedderburn, and my supportive and welcoming colleagues from the start of my academic career at Glasgow, and of course my fabulous colleagues from Edinburgh as well, and some of my students past and present, including from the Law School Choir, happy days. And I'm also so pleased to be joined by colleagues from the Scottish Law Commission this evening. Of course, along with fellow heraldists and officers of arms, and a wide range of those that I have enjoyed working with, challenging, collaborating with over the course of my academic career. It's also very important to me to have family here, especially my husband and sons. There's nothing like working in family law to make one reflect on one's own family life. And I'm sure it will be absolutely worth all the bribery that was required to get my sons here this evening. And while it has been a great pleasure to have such a wide-ranging audience, it has made preparing this something of a challenge. I have here this evening family lawyers, I have family, I have lawyers. So I've tried to cater for all of you, but do wish me luck. In fact, in preparing this lecture and reflecting on family life and family law, I've been struck by the very great privilege it is to stand here at all. Things could have been so very different. So I'd like to start by considering the life of a fellow Glasgow graduate. This is Edith McDougall. She matriculated at Glasgow University in 1923 at the age of 16. I think this photograph was taken a decade or two later. So fairly young, she matriculated at 16, and she studied courses in English language, English literature, French, and British history. And she graduated in 1928 with an MA, second-class honours in English language and literature. And she was by no means one of the first cohort of women to graduate from Glasgow. Women had been graduating there in medicine since the 1890s, and she was certainly an early adopter, as they say, not least because she took an honours degree, which was much more unusual 100 years ago. Studying at university would not have been a typical or an inevitable path for most women at that stage, and especially not one from her modest background. But I think one reason that Edith did so can be found in that family background. She was the youngest of 7 children of Peter and Grace McDougall, and they lived on the west coast of Scotland at Hunter's Quay, just outside Dunoon. Peter McDougall owned 2 grocer shops. Here is the one at Kern. And such was the family commitment to education that he and his wife put 6 of their 7 children through university or technical college, Edith being one of them. So while sending your children to university was certainly not standard practice in the 1920s, it was in the McDougall family. By 1928, age 21, Edith had graduated with her honours degree, and what career options were there? Well, not many at all, primarily primary teaching. So she took up a role as a primary teacher, as indeed did her 2 sisters, who were both also Glasgow graduates. Now, I've honestly no idea if she wanted to be a primary school teacher. Perhaps it was her greatest ambition. Or perhaps she would have made a different choice if choices had been open to her. And even then, with these limited career prospects, there was another barrier. In 1935, she got married. Here she is on her wedding day with her husband, Percy Davis, on the steps of the University Chapel at Glasgow. And the marriage bar meant that she was no longer eligible to work as a teacher. The marriage bar for teachers was not repealed until the Education Act of 1944. So, despite the fact that she actually had a higher academic qualification than her husband, he had a bachelor's degree in engineering and she had her master's, her career options were heavily constrained and then terminated entirely on marriage. By 1935, therefore, this highly qualified and intelligent young woman was a stay-at-home wife, where she remained, becoming in due course a stay-at-home mother, with the arrival of 3 sons in 1936, 1939, and then in 1941, she gave birth to her 3rd son, my father, Colin Davis. Sadly, my dad passed away 8 years ago, so he can't be with us this evening, but one of his brothers, Edith's 2nd son, and my uncle, is here this evening. Like my grandmother Edith, I have an honours degree from Glasgow University, and I'm very proud of that connection between us. but the difference between graduating in 1928 and graduating in 1999 seems stark. Admittedly, I also ended up in a classroom, one of 19-year-olds rather than 9-year-olds, but my choices were not constrained by my gender or by marriage or by children. And the differences we face in our lives become even starker when we turn from family life to family law. What did family law look like in the 1920s and 30s? Well, there were some very significant developments around this time in relation to child law, including the Guardianship of Infants Act from 1925. Until then, the father had a more or less absolute right to the care and control of his children. It could only be denied on proof of serious physical or moral danger to the child. Not just physical or moral danger, but serious physical or moral danger. But the 1925 Act changed that and required the court instead to consider the welfare of the child as its first and paramount consideration. So the father no longer had an untrammeled right to custody, and this was a major shift. Also at this time, adoption was not legally recognised, and I always find it surprising that adoption was only recognised in law less than 100 years ago. Informal care arrangements were not uncommon, of course, but there was no way that any arrangement could be recognised in respect of the child's parents in law until the Adoption of Children Scotland Act in 1930, which recognised and introduced for the first time full legal transplant adoption, which we still have today. But my focus this evening is primarily on adult relationships, so my next example comes from the sphere of marriage, and specifically divorce. When my grandparents, Edith and Percy, got married in 1935 in the University Chapel, divorce was still regulated by the laws of post-Reformation Scotland. Here we go. 1560, divorce was recognised on the grounds of adultery, and in 1573 on the grounds of desertion from the marriage. I've illustrated this slide with a photo of the panel from the Great Tapestry of Scotland showing the Reformation. And if you've not been to Galashiels to see the Great Tapestry of Scotland, I would strongly recommend it. It's fascinating. So here we have the Reformation panel. So when they got married, divorce laws had been unchanged for over 400 years, nearly 400 years. There was a very significant change just 3 years after they married, although I think that was a case of coincidence rather than correlation, when the Divorce Scotland Act was introduced in 1938. And this retained adultery and desertion as grounds for divorce and added new grounds. Here we have them: cruelty, incurable insanity, sodomy as it was referred to, and bestiality. Now, I confess I haven't carried out the research to find out whether bestiality was a pressing social ground for divorce in the 1930s, but there we have it. I can report, however, that although the grounds for divorce were extended, they were not required by Edith and Percy, who remained married until my grandfather's death in 1974. Now, I'm not going to talk through the evolution of family law from 1928 to 1999, but there were a number of important legal and social landmarks. Perhaps, most importantly, was this development in the 1960s when, as Philip Larkin told us, sexual intercourse began in 1963, which was rather late for me, between the end of the Chatterley ban and the Beatles' first LP. I have to say, I was slightly hesitant about using this verse from Philip Larkin because of the risk of tricky questions from certain elements of the audience. I'm conscious, having my sons in the room, I'm likely to be asked when I get home what exactly an LP is. And of course, with members of the judiciary present, it's always a risk mentioning the Beatles. So for the benefit of Lord Drummond-Young, they're a popular beat combo, I understand. Other legislative reforms, which are still in force today in this period, include these acts here, all hugely important and have had a profound impact on family law in Scotland. This takes us up more or less to my own graduation in 1999, and since then there have also been very significant changes. In the new millennium, the first change that I want to mention is the Civil Partnership Act of 2004, and then in 2014 we've recognised same-sex marriage. So until then, adult relationships in law had been very clearly heterosexual. Civil partnerships were then extended in 2020 to heterosexual couples. Cohabitants were also recognised with the Family Law Scotland Act of 2006, giving the right for a cohabitant to make a claim against a former cohabitant at the end of the relationship, or against the former cohabitant's estate if the relationship ended through death. In relation to children, there was reform to the Children's Hearing Scotland Act, the Children's Hearing System through the Act of 2011, and then the smacking ban was introduced with the Act of 2019, and further changes imminent, not least with the Children's Scotland Act 2020, large parts of which are eagerly awaited to be introduced. We also look forward to the incorporation of the UN Convention on the Rights of the Child, which is due next month. But of all the changes since the turn of the millennium, and perhaps the most fundamental, I think, was the Human Rights Act of 1998, when it came into force in October 2000. This made the European Convention on Human Rights a daily reality for domestic lawyers, and for present purposes, it put Article 8 and the Article 8 right to a private and family life firmly on the agenda for family lawyers, where it has remained ever since, with a radical and positive impact on family law. However, although Article 8 is well used by family lawyers in the context of respect for family and private life, it has also shaped privacy laws quite dramatically. Now, privacy isn't a functional right in the way that marriage, civil partnership, divorce, or parental responsibilities and rights are, but it's a substantive human right which, in my view, has been somewhat neglected in the field of family law. So, in the rest of this lecture, I'd like to explore family law's relationship with privacy. And I'd like to start by providing a brief overview as to why privacy is so important to individuals, and then explore the relationship between family law and privacy. So first, privacy. What is privacy and why is it important? Well, Daniel Solov has observed that privacy is a sweeping concept, and it encompasses, amongst other things, freedom of thought, control over one's body, solitude in one's home, control over personal information, freedom from surveillance, protection of one's reputation, and protection from searches and interrogation. Perhaps unsurprisingly for such a broad and sweeping concept, privacy can be conceptualized in different ways, such as the right to be let alone, the right to control access to your personal information, or to control and limit access to intimate aspects of one's life, including intimate relationships. So privacy encompasses many different facets, typically all revolving around control and autonomy, the right and ability to choose what happens to your body, your persona, your information. And Professor Sir Neil McCormick has explained just why privacy is so important. It protects some kind of desire for seclusion. This desire for seclusion should not be construed in all cases as a desire to exclude all other human beings from one's life or some aspect of it. Rather, it is a desire to have the last say on which other human beings will be brought within the circle of one's seclusion for certain purposes. And it's this control which is so fundamental. Intimate relationships are built on trust, and trust can be achieved by sharing intimate or personal information or activities within a select circle, a circle of seclusion. If there was no right to privacy and no private sphere, if everything was under surveillance and publicly broadcast, there would be no basis for trust and a reduced scope for intimate and trusting relationships, which are, of course, the relationships at the very heart of family life and family law. So privacy is a fundamental precondition for human flourishing. Only by having control over one's private information, one's body and one's life, one's autonomy, can one live a good life. And we recognise this more generally in law with the doctrine of the breach of confidence and the information privacy right secured by Article 8. So a helpful reminder of what Article 8 says. The right is stated in paragraph 1, everyone has the right to respect for private and family life, his home and his correspondence. The exception is set out in paragraph 2. There shall be no interference with this right by a public authority, except if it's in accordance with law and it's necessary in a democratic society. And it lists some of the reasons for that. Interests of national security, public safety, economic well-being, prevention of disorder or crime, protection of health or morals, or for the protection of rights of freedoms of others. So Article 8 encapsulates privacy rights in the European Convention, and I'd like to turn now to look at how this interacts with privacy rights. Privacy pulls in two different directions in family law, and I think this is one of the problems with it. On the one hand, we need to respect the privacy of individuals and not invade that privacy. And what can be more private than one's family life with all its ups and downs, its intimacies and confidences? Surely there must be a sphere into which the state does not intrude. But on the other hand, we must be vigilant and ensure that privacy is not used as a shield by those who perpetrate abuse, to keep abuse behind closed doors and victims trapped in abusive and hurtful family relationships. Privacy should not be an excuse for the state to abandon those who need the protection and the remedies that the law can provide. So we have this tension. Privacy should not stand in the way of protection, but the law should not invade an individual's privacy unnecessarily. And I'd like to explore these two elements in more detail. My hypothesis is that there's been both over-reliance and under-reliance on privacy, with damaging consequences in both cases. Historically, over-reliance on privacy and the belief that the family is a private sphere has led to abuse and victims being denied protection in law. While under-reliance, or failure to recognise privacy rights, has led to unnecessary and unjustified invasion of privacy in order to access rights and remedies in family law. So I'm going to start by exploring the over-reliance on privacy, a justification for the state staying firmly out of family life. And this has had, over time, damaging and devastating consequences for vulnerable family members. Traditionally, the family was seen as a private unit and one in which the state should not interfere. And within that family unit, the authority of the husband and father was unquestioned and unquestionable. His rightful authority was maintained through force. Society was therefore centred on the ideal of the subordinate position of women in the family and of the right of men to dominate and control their wives and children by various means, including force. And the role of privacy in facilitating this has been explored by an American academic, Professor Elizabeth Schneider, in an article rather tellingly called The Violence of Privacy. And she refers to an American case from 1965, which established the principle of marital privacy, Griswold against Connecticut. And as she says, the concept of freedom from state intrusion into the marital bedroom takes on a different meaning when it is violence that goes on in the marital bedroom. The concept of marital privacy, established as a constitutional principle in this case, historically has been the key ideological rationale for state refusal to intervene to protect battered women within ongoing intimate relationships. Curiously, when this case was being decided in 1965, a young woman named Brenda Hale was a law undergraduate at Girton College, Cambridge. Sadly, unlike my grandmother and myself, she did not have the benefit of a Glasgow education. But despite this setback, Miss Hale persevered, ultimately finishing her career, as we know, as the President of the Supreme Court. And towards the end of her time on the bench, Lady Hale reflected on family law in 1965 when she had been an undergraduate. And although remedies for domestic abuse were starting to emerge at this time, she observed that there was still a strong feeling amongst the police and other authorities that it was wrong to intervene between husband and wife. But as things started to shift in the 1960s and 70s, with the recognition that family was not a private world with the husband at its head as the unquestioned authority, we can see a pushback against that shift. For example, when Scottish Women's Aid started to campaign for women's refuges in Scotland in the 1970s, certain politicians were firmly opposed. Opening women's refuges in Scotland? Well, they are playing with fire if they attempt to interfere between a husband and wife in this way. Some of these women might well deserve the batterings they get from their husbands. Thank you to Mrs. Scott Walker for that radical insight in the Guardian in August 1975. Over in the Glasgow Herald, not wishing to be outdone, Sir Nicholas Fairbairn chipped in. I know that there are battered wives in Britain, but why should the government get involved in a family squabble? So abuse of women and children was characterised as a private family matter, a squabble into which the state should not intervene. Perhaps the most troubling example of the authority and the rights of the husband, which were supported by the state, upheld by the state, was the doctrine of the husband's immunity for marital rape. The law, as set out by Baron Hume in 1797, recognised that on marriage, a woman gave irrevocable consent to sexual intercourse with her husband, and therefore her husband could never be guilty of raping her. Her right to bodily autonomy, never terribly effective in the first place, was lost entirely on marriage with the sanction of the state. But in 1989, less than 40 years ago, the High Court of Justiciary, sitting as a court of appeal, finally put paid to this doctrine and confirmed that there was no longer a defence to a charge of rape available to the husband based on the fact that the parties were married. Now, I find this case staggering, in part because it was so recent, but also in part because of the arguments run by the defence counsel for the husband, who did his best to argue that the law, set out first in 1797, was still good law. As reported by the Lord Justice General, Lord Emsley, counsel for the husband argued that there has been no change in the social position of women such as would justify subjecting a husband to a charge of rape upon his wife. Any changes that there have been have had no bearing upon the sexual relationship of a husband and wife. The biblical view that a husband has dominion over his wife still applies in 1989. He continued, outlining the allegedly dire consequences which would flow if marital immunity was removed. As he said, it will take away from women a number of basic rights, and I'd like you to reflect on these basic rights that he thinks women are entitled to. The right to forgive, the right to tolerate and decide whether the marriage should survive or not, the right to change her mind. Fortunately, the Lord Justice General Emsley and his colleagues were not impressed with this at all, and in holding that whether or not Hume was right in 1797, it was certainly not the law in Scotland in 1989, they cited with approval the leading English scholar and jurist Glanville Williams. Here he is here. And he said that the reason traditionally given for the general rule is the totally unconvincing one that the wife's consent is given on marriage and she cannot revoke it. And he went on to describe this theory as an authentic example of male chauvinism. So that at least was consigned to the history books in 1989. But these examples, going right up until present time, show that families were conceived of as a place beyond the regulation of the state, where the husband's rights prevailed over the rights and autonomy of his wife and children. And the home was a private domain into which the state would not and should not pry. Now, men also suffered under this regime because when husbands were abused by wives, the state was not particularly interested either. The patriarchy was firmly of the view that men should be able to stand up for themselves and not be abused by their wives. The need to defer to the privacy of the family and family life was therefore highly problematic. And returning to Lady Hale, the experience of domestic violence and abuse has taught us that doing nothing is not a neutral option. Refusing to intervene or provide a solution legitimizes and sustains the power of the abuser. But the good news is that things have shifted, and the work of Scottish Women's Aid and other individuals and organisations over the last 50 years has produced radical change. It remains the case that, tragically, domestic abuse and child abuse are still an all too prevalent feature of life in Scotland, but we no longer refuse to intervene. The sanctity and privacy of the family is no longer a reason for the state to stay out. The police will now investigate, take matters seriously, pass the report to the Crown Office, and the Crown Office will prosecute. In relation to civil remedies for domestic abuse, there is still work to be done, and that is my current project at the Scottish Law Commission. But in the context of state responses to domestic abuse, I think this quote from a senior prosecutor at the Crown Office and Procurator Fiscal Service from 2018 is instructive. Anne-Marie Hicks has observed that dealing with domestic abuse has always been a matter in which people have said that there is a danger that we stray into family life. Even under the current law, it is sometimes asked whether we criminalise normal behaviours in a relationship. We do not. Controlling, frightening, humiliating, degrading, or punishing someone is not how I would define normal friction in a relationship, and once we get to these boundaries, that is where the criminal law should step in. So while it is important to respect the privacy of the family, we now recognise that abusive relationships are not normal family life and do not merit protection. The state no longer holds back from so-called family squabbles. And this is the critical element in all the examples so far. There should be no cloak of privacy in the marital or family sphere to protect abusers from the criminal law or to deny victims a remedy. Criminal conduct within the family justifies the intrusion into family life to protect the vulnerable and justifies any invasion of privacy. No matter how long it has been in coming, it is undoubtedly a positive step that at last privacy no longer operates as a lock on the front door, barring the state from entering. But this shift concerns criminal and abusive behaviour. What about my second category? And this is where the state, my concern is that the state compels disclosure of private information by family members in order for those family members to access their civil rights and remedies. And as I hope to show, in some cases, this is very much an unnecessary invasion into the privacy of individuals. My concern is that access to legal rights and remedies should not depend on the compelled disclosure of private information where it's unnecessary, but that this has never been scrutinised through a privacy lens. And I think one reason it's been neglected is the very real risk, as we've just seen, that privacy in families can be dangerous. So, in fact, we now recognise that privacy can be dangerous within families, and there's a concern that by recognising privacy rights in families, we run the risk of hiding abuse and allowing abusers to stay concealed. I also find it deeply troubling, however, because of the inherent hypocrisy here, at least historically, when domestic abuse and child abuse were categorised as a private issue where the state should not tread, but yet the courts have willingly, enthusiastically it sometimes seems, scrutinised the most intimate details of relationships in other cases, as we will see. In this case, the privacy that we're concerned with is primarily information privacy and the compelled disclosure of private information to the courts. So for Article 8 to be engaged to protect those privacy rights, we need 3 elements. There must be a reasonable expectation of privacy in the information. The information must have the necessary quality of privacy, and not all information does so. Disclosing to the court simply that you're married does not engage any privacy rights. The first element, therefore, is this need for a reasonable expectation of privacy, and information regarding a person's intimate relationship, their health, sexual conduct, finances, would typically constitute information that meets this test. There has been specific judicial recognition that sexual behaviour in private is indeed part of a core aspects of an individual's autonomy. The second element is whether the disclosure is in accordance with law. And actually, I think this is at the very heart of my concerns here. The disclosure may be to comply with domestic law. You may need to disclose in accordance with law to pursue the legal remedy that you're seeking. But that is not necessarily in accordance with the ECHR, the European Convention itself. And I would argue that it's potentially the law here which breaches Article 8. However, even if it is in accordance with law, I think the compelled disclosure of private information typically falls at the next hurdle. It has to be necessary in a democratic society, and it's difficult to see in the examples that I will give that this disclosure of information is indeed necessary in the interest of national security, public safety or economic well-being, for the prevention of disorder or crime, or for the protection of health or morals. I've highlighted the last two as I think the most likely candidates if we could manage to show this, or for the protection of the rights and freedoms of others. In family law litigation, however, there is another issue. And this initial invasion, this compelled disclosure of personal information to the courts, can be compounded by a further invasion of privacy interests if the court judgment is published and individuals are identified in that court judgment. Now, one of my other strands of research is on transparency and privacy in the courts, and that work has highlighted that the Scottish courts are doing their best to protect litigants' privacy by steadfastly just not publishing very much at all. But that's a battle I'm going to fight another day. For now, I want to note that it remains a possibility that the judge or sheriff could publish the judgment in your family law litigation, thereby disseminating some or all of the private information that the law has compelled you to disclose in the first place. So an individual's privacy interests can be harmed through the invasion, the compelled disclosure to the court, and indeed to the solicitors and advocates representing you, and then by dissemination, so by publication in a case report. And both these breaches are sanctioned by and required by law. And I could point to many family judgments where deeply personal information is disclosed in the judgment, and there's no guarantee of anonymisation. Indeed, the competing interest of transparency would suggest that there should be no anonymisation, and I have a lot of sympathy for that perspective. The courts should publish their decisions, and justice must be seen to be done. One response could, of course, be that if you don't wish to wash your dirty linen in public, then don't seek a remedy through family law. You won't need to disclose this information to the courts, and there'll be no published case report. But that seems a slightly disingenuous response. The law is there to offer remedies, so unhappy individuals should be able to seek those remedies with no unnecessary barriers. At its most fundamental, some of these legal actions affect an individual's legal status, and there's no other way to access this. If you wish to end your marriage, divorce changes your legal status, and it's the only exit from the marriage. There should be no obstacles to accessing these legal rights or remedies. I think it's also important to note that privacy is a fairly sophisticated concept, and it's possible to accept that someone can willingly choose to disclose to share information with one party, but to be vehemently against sharing it with someone else. And that's a critical factor of control at the heart of privacy. And it was outlined by Neil McCormick in the quote earlier. Privacy is frequently about choosing who to tell and who not to tell. Family law, my concern is, often removes that choice by compelling the parties to disclose this information to their agents and to the court. So in the time available, I'm going to set out 3 examples in the context of adult relationships. To signpost the way, we're going to start by looking at divorce and dissolution, move on to impotence, and finish with cohabitation. So, divorce. The Divorce Scotland Act 1976, we've moved on since the act that was passed just after Edith and Percy got married. We're now on to the 76 Act, and it provides for divorce where the marriage is irretrievably broken down. But to show that the marriage is irretrievably broken down, the pursuer must establish one of 4 facts or categories. Adultery, behaviour, they need to show that since the date of the marriage, the behaviour of the defender has at any time behaved in such a way that the pursuer cannot reasonably be expected to cohabit with them. They could also show non-cohabitation for 1 year with the other party's consent, or non-cohabitation for 2 years. And in establishing any of these bases for divorce, to show that the relationship has irretrievably broken down, there's a potential for an invasion of privacy. The court has to be satisfied that the basis is established, so it therefore requires evidence of that adultery, that behaviour, or that non-cohabitation. It's highly likely that some or all of this evidence will be information where there is a reasonable expectation of privacy. So if you're looking to prove adultery or behaviour, you're going to have to detail the relevant conduct of your spouse and probably also the impact it has had on you. Even the non-cohabitation ground, which seems innocuous, simply that you're no longer cohabiting, could require the disclosure of intimate information about the parties, and this is because it's possible for a couple to be non-cohabiting while still living under the same roof. The relationship may be over, even if the parties have not yet moved into separate accommodation. And where they are still living under the same roof, but not cohabiting, then the court is going to be looking for evidence that the marriage has moved on from an intimate partnership. And that, of course, will require evidence of daily living and sleeping arrangements. Now, in reading divorce cases over the years, whether for adultery, behaviour, non-cohabitation, or indeed the older ground of cruelty, there are many which disclose deeply personal information about the parties. But the example I'm going to share is a recent decision, and it's actually from England and Wales. Owens against Owens from 2018. It's a very rare example of a divorce case which made it all the way to the Supreme Court, and such is the significance of this case that it even has its own Wikipedia page. Mrs. Owens became something of a celebrity in family law circles. Here she is, along with the relevant Wikipedia page in the background. But I'm not actually concerned with the legal merits of the case. I want to examine the compelled disclosure of private information. So Mrs. Owens petitioned for divorce on the basis that her husband's behaviour was such that it was unreasonable to expect her to cohabit with him. Sometimes shortened to unreasonable behaviour, but the family lawyers can have a discussion about that later. Now, Mr. Owens defended the action. He objected to the divorce. So Mrs. Owens then had to evidence his behaviour and the impact it had had on her to show why it was unreasonable to expect her to put up with it. In an attempt to meet the standard required by law, Mrs. Owens provided details of 27 incidents from her married life. It was accepted that these incidents were in many ways mundane. A trip to the pub for dinner one evening when Mr. Owens sat silently with his head in his hands, refusing to speak to her. A meal out with a friend when Mr. Owens was allegedly critical of his wife in front of the friend, causing the friend and Mrs. Owens embarrassment. Here's one of the most detailed, labelled as the airport incident. It took place at Cancun Airport. Mr. Owens reported to Mrs. Owens that he'd seen a suitable present for the housekeeper at the departure lounge of Cancun Airport. Mrs. Owens went over to see what he was referring to, but could not find it, so instead she purchased a silver tortoise necklace, which she knew the housekeeper would like. When Mr. Owens found out that Mrs. Owens had ignored his suggestion, he lost his temper. He raised his voice so that those around him could hear him berating Mrs. Owens and snapped, "Why did you not listen to me?" And he demanded, "Why did you not buy what I told you to?" This caused Mrs. Owens extreme embarrassment as he was visibly chastising her in front of numerous strangers. It's perhaps not terribly salacious. We're not really in the same territory as the divorce of the Duke and Duchess of Argyll in the 1960s. But Lady Hale in the Supreme Court recognised the cumulative impact of these events on Mrs. Owens. As she said, this was a case which depended on the cumulative effect of a great many small incidents, said to be indicative of authoritarian, demeaning and humiliating conduct over a period of time. Those who have never experienced such humiliation may find it difficult to understand how destructive such conduct can be of the trust and confidence which should exist in any marriage. The pinpricks of all these incidents can add up to far more than the sum of their parts. And I would suggest that this is compounded, significantly compounded, by being required to disclose all these to your solicitor, and then in court, and then have the published judgment freely available online for everyone to read and base lectures around. But after baring her soul, washing her dirty linen very much in public, as required by law in order to get a divorce, the judge at first instance held that these examples were just part and parcel of the banal reality of married life, merely examples of events in a marriage, he said. I am satisfied that the wife has exaggerated the context and seriousness of the allegations to a significant extent. They are all, at most, minor altercations of the kind to be expected in a marriage. Now, that did not meet the statutory test to demonstrate the irretrievable breakdown of the marriage, and consequently, he refused the divorce. Despite the best efforts of the Court of Appeal and then the Supreme Court, the judge at first instance had not erred, and his decision to refuse the divorce was upheld, rightly so. The couple had to remain married, not living together, but married. I think there's something very troubling about a legal system which compels disclosure of these intimate personal details of a marriage or a life. in pursuit of a legal end, especially, of course, when there's no guarantee that the end will be achieved. Is there a solution to this? Well, the Scottish courts, especially the Court of Session, have developed a very pragmatic solution which works. In divorce cases which go to proof on matters of financial provision or child contact, then the judge will typically grant the divorce in the most general terms before focusing the decision on the points that are actually in dispute. And here's a recent example from Lady Wise. She said, so far as the merits of the divorce action are concerned, on the basis of affidavit and oral evidence led, I am satisfied that the marriage has broken down irretrievably and there is no prospect of reconciliation. The basis for divorce is undefended and decree will be pronounced when orders for financial provision are made. In fact, she doesn't even disclose here whether the irretrievable breakdown was evidenced on adultery, behaviour or non-cohabitation. So it's very discreet and it's very helpful. The judge explicitly confirms that the statutory test for divorce is met, decree can be granted, but in such general terms that the privacy of the parties is protected, at least as far as the case report. As a practical solution, I think it's very neat, but it's not perfect for 3 reasons. In the first place, it largely relies on the divorce itself not being defended. If Mr. Owen's Scottish cousin were to defend a divorce action, the judge would need to reach a decision on the merits and set out the evidence. Secondly, as a published judgment of the court, it's slightly problematic for those of us who rely on judicial precedent. It's not at all clear what the facts are required to prove the irretrievable breakdown of the marriage. So practitioners get no guidance as to what standard must be achieved or what evidence must be led, and academics get no evidence on which to examine the shifting interpretation and application of the law. And for those of us working in doctrinal law, the case law is our bread and butter. And thirdly, and more fundamentally, as Lady Wise narrates, she has properly examined the written and oral evidence. So although she respects the parties' privacy by not publishing the details, nevertheless, she's required by law to ensure that the irretrievable breakdown of the marriage has been established, and the intimate details of the breakdown, therefore, have still been disclosed to the parties' agents and in court. And I have heard, perhaps apocryphally, perhaps not, of one sheriff whose commitment to scrutinising the evidence in divorce cases was such that he once demanded that the solicitors produce the video evidence of the adulterous conduct just to prove the adultery. Right. My concern is that this is highly unsatisfactory when the end in sight, the divorce, could be achieved without any infringement of privacy. And I think this is the key point. Without the need to couch the resulting judgment in vague terms and without the need to disclose this evidence in the first place. An invasion of privacy can be justified if it's necessary to achieve the legal end sought. But this is not the case with divorce. It doesn't need to be evidenced by adultery, behaviour or non-cohabitation. So, in my view, it's not necessary to compel disclosure of private information in order to grant a divorce. And we can see how this can be done if we return to England and Wales. Now, this is the happy postscript to Mrs. Owen's story. Just 2 years after she concluded her legal battle, unsuccessfully, in the Supreme Court, Parliament enacted the Divorce, Dissolution and Separation Act. And it introduced no-fault divorce in England and Wales. Either or both parties to marriage may apply to the court for a divorce order which dissolves the marriage on the grounds of irretrievable breakdown. That application must be accompanied by a statement that the marriage has broken down irretrievably, and the court must take that statement as conclusive evidence and then make the divorce order. No need for any further evidence, a statement that the marriage is irretrievably broken down. So divorce can now be obtained in England and Wales on the basis of this statement from one or both parties, and the courts must then grant that divorce. No need for a future Mrs. Owens to go through that painful litigation. And in fact, this act was a direct result of legal campaigning which followed on from the Owens decision and the fairly unusual levels of judicial disquiet which were expressed by members of the judiciary on the back of that case. So Scotland is now out of step with England and Wales, and indeed with much of Europe, in maintaining fault-based grounds for divorce, which require the party seeking that divorce to disclose private information. And if we analyse this through the lens of Article 8, I think it cannot be justified. As I mentioned earlier, Article 8 applies when there's a reasonable expectation of privacy, and that is highly likely to be the case in a divorce action. The disclosure must be in accordance with law. Now, my argument would be that the requirement in law for that disclosure is not in accordance with human rights, at least. But any invasion of the privacy would only be justified if it is necessary in a democratic society. And my argument is that it's very hard to see how the disclosure of that information for divorce is necessary in a democratic society when no-fault divorce is perfectly possible and is practiced in many European countries. We know from these jurisdictions that divorce can be achieved without requiring that level of proof. Accordingly, where the parties are required by the state to disclose private information in order to get a divorce, an absolutely fundamental provision if you wish to exit a marriage, then I think the state breaches the parties' Article 8 rights. For completeness, and for the family lawyers in the room, I just want to flag up that there is a simplified divorce procedure which exists and provides a very practical solution, a quick route to divorce. It's only available on the non-cohabitation ground and if there are no children under 16. It definitely addresses my concerns for those who are eligible to use it, and of course it rather proves that it is possible to frame divorce practice in such a way to avoid that invasion of privacy. But it's not universally available, and as long as non-simplified divorce remains available, my concerns remain. Moving on now, impotence. I think this family law doctrine probably provides one of the grossest invasions of privacy in Scots law. It is the only ground on which a marriage can be annulled. Marriages may be null and void for various reasons, but they can only be annulled, set aside, based on one party's impotence. We have a definition here of impotence. Professor Clive and Sheriff Wilson have defined impotence as the permanent and incurable ability of one spouse to have sexual intercourse with the other. The common law doctrine says that if a man and a woman marry, and it must be a man and a woman because impotence has no application in same-sex marriage or in any civil partnership, possibly a concern in its own right. If a man and a woman marry and are unable to consummate the marriage, then that marriage can be set aside. To 21st century eyes, this level of scrutiny from a committee of medieval ladies is a very curious and antiquated doctrine. The Scottish Law Commission recommended the abolition of impotence in its 1992 report on family law, sadly not yet implemented 30 years later. Obviously, any party to a marriage who's seeking to have it annulled on the basis of impotence has to bring highly personal and private information to the court to achieve that declarator. If we're concerned about an invasion of privacy here, then one response is to point to the very low numbers of cases. Impotence has never been widely used in Scotland. There have been just 9 decrees of nullity in the last 10 years. But arguably, rather than suggesting that an invasion of privacy is not a significant concern, these low numbers suggest that the doctrine is not of any practical value and could happily be abolished. Low numbers are not a new development. In Alienated Affections, Dr. Leah Lenneman looks at divorce and separation in Scotland in a 150-year period from 1684 to 1830. And in that period, she records 6 cases of impotence against 904 of divorce. So impotence has always been a very low or infrequently used doctrine. The frank evidence she cites from the cases, I mean, feel free to go and have a look at her book, rather Bridgerton-style reading, quite frankly. One wife declared that her husband was never betwixt her legs, nor had any erection or standing in his privy parts. And reflecting the contemporary panic of witchcraft, another wife had to depone that she had not used any charm to make her husband impotent. When we turn to the cases at the end of the 19th century and into the 20th, there's a marked change in language to a supposedly more scientific assessment as the judges examined impotence in detail, considering opportunities, attempts, medical evidence, and psychological reasons for failing to consummate the marriage. And they often attributed the woman's supposed impotence to her invincible repugnance or repulsion. These cases very much give the lie to the examples in the first half of this lecture where the state and politicians were reluctant to interfere in family life. When it comes to impotence, the state has been more than happy to require the courts to peer behind bedroom doors. Anyway, while impotence cases rarely trouble the courts, it remains the case that an action for declarator of nullity of marriage based on impotence must be one of the most intrusive civil remedies in Scotland. But so long as we continue to recognise impotence as the ground to annul a marriage, then I don't see any way around this. The disclosure of private information is required to prove the claim. Instead, the solution would seem to be to abolish the doctrine, and I would argue that the invasion of privacy is just another argument to implement, finally, those recommendations from the Law Commission from 1992. My third example is from cohabitation. Now, I did a Google search for illustrations of cohabitation, and this came up, and it says, she's nae your wife. I suspect it's probably more accurate for adultery, but anyway, it came up for a search on cohabitation. We're very fortunate in Scotland to have legal recognition of the need for a financial remedy at the end of a cohabiting relationship where one party has suffered economic disadvantage. And in order to make a claim under the Family Law Scotland Act 2006, the parties will need to establish that they were cohabitants and that there has been an economic advantage or disadvantage. That's the current law. Reform might be on the horizon, thanks to a recent report on cohabitation from the Scottish Law Commission, and it's currently with the Scottish Government for consideration. For now, however, the test for establishing that the parties were cohabitants is set out in Section 25 of the Family Law Scotland Act 2006. A cohabitant is a member of a couple who are or were living together as if they were spouses, and in determining whether Party A and Party B were cohabitants, the court shall have regard to the length of the period in which they live together, the nature of the relationship, and the nature and extent of any financial arrangements. So the judge or sheriff will need to be satisfied that the parties were cohabiting as if they were spouses, and to establish when they stopped cohabiting as if they were spouses, and presumably financial evidence as well. This can lead to some toe-curlingly awful evidence being published. I will spare you the worst, and I will spare the parties by not naming them from the case reports. In one case, which was published with no anonymisation, full details are out there online for anyone who wants to see, the details of the cohabitation came down to disputes about sex and plumbing. And that's not a euphemism, there was actually an issue with the drains. As the sheriff reported, the defender admitted that the pursuer slept with her on Christmas Eve, but she said they did not have sexual relations. The pursuer said that they did. The defender stated that she asked the pursuer to stay longer because she wanted him to sort out the drainage problem. The pursuer denied that was the reason he stayed, but accepted that he did deal with the drainage problem. This evidence reported in court, along with other facts of their life together, allowed the court to reach a decision as to the cohabitation under Section 25. Is it really appropriate for these details and more to be the subject of judicial scrutiny and then publication? In fact, reflecting problems with the Section 25 definition, Sheriff Morrison, in another decision, set out a handy 12-point list of factors that could establish, and I'm going to put these up briefly on the slides now, the length of time during which they lived together, the amount and nature of the time they spent together, whether they lived under the same roof, whether they slept together and separately, whether they had sexual intercourse, whether they ate together, whether they had a social life together, whether they supported each other, talked to and were affectionate to each other, outward appearances, financial arrangements, including childcare, intentions of the parties, and physical separation. Would any of us willingly have evidence of any or all of these 12 points of our intimate lives discussed in court, the subject of examination and cross-examination, and then potentially set out in the judge's written decision? Again, there is potential for considerable intrusion into private lives here. Is there a solution? Well, the problem is, I accept the court must be satisfied on the evidence that the couple were cohabiting. What evidence would be sufficient to establish that? And I think that perhaps in this case there is no answer. How else can a judge determine a question of cohabitation and then compensation for economic advantage or disadvantage without the disclosure of this information? Whereas I think divorce can be achieved without disclosing any private information, so that any compelled disclosure is a breach of Article 8, I think that the only way cohabitation disputes can be resolved is through the disclosure of this information. Instead, the only option is to try to respect the privacy of the parties, is to ensure that the information disclosed is the minimum required. To bring all this together, I think it's clear that privacy has been under-theorised in family law, and the recent impact of Article 8 privacy protection has not been felt within family law, as I've tried to show. For too long, a general concept of privacy and the sanctity of the family unit was used as a reason for the state to stay out of family relationships where abuse was perpetrated in households. While simultaneously, the state invaded and continues to invade privacy, particularly informational privacy, by compelling the disclosure of private information in order to access legal rights and remedies. Without a clear understanding of the value of privacy in family life and the balance to be struck between protecting parties from abuse and protecting their privacy rights, both these positions are wrong and harmful. Informational privacy is well developed in other contexts. The challenge for us is to apply that understanding in family law to ensure that there is no requirement to disclose information to achieve a particular legal end if that legal end can be achieved without it. And the clearest example is, of course, divorce. Reform is required to remove the need to prove the breakdown of the marriage, and recent reform in England and Wales shows us how this can be done. I think my second proposal is that doctrines which invade privacy but serve no relevant function in the 21st century should be abolished, and the example here would be impotence. My third proposal is that where any disclosure of private information is required, and the courts do genuinely need that in order to resolve the dispute between the parties, then the emphasis should be on minimising the invasion to ensure that the disclosure is necessary in a democratic society to protect the rights of others. And the example here would be cohabitation. And finally, we must recognise categorically that privacy can never justify abuse. Criminal conduct should never be concealed by a cloak of privacy. As Elizabeth Schneider has stated, we should aim for an understanding of privacy in families which is grounded in equality, is viewed as an aspect of autonomy, that protects bodily integrity and makes abuse impermissible. It should be based on a genuine recognition of the importance of personhood. And this would be a far more nuanced and sophisticated approach to privacy in family law than is, I think, evident so far. I started this lecture by reflecting on the world my grandmother lived in when she was an undergraduate and the changes in family law over the last 100 years. And I'd like to finish off this evening by returning to her and by completing that circle. I was only 4 when she died, so we didn't have long together. But here we are, outside People's Hydro. I'm the smallest one there in my red dungarees, along with my big sister Denise, who's here, and my mother, and my grandmother, Edith. Thank you very much for your attention.